As threats have risen to democratic principles of free speech and individual liberty, so have concerns over the effectiveness of institutions meant to act as checks and balances. But a series of recent bail orders by courts appear to indicate that the judiciary, or at least a part of it, is stepping up to the role as a gatekeeper of democratic norms. Let's begin with today's order by a Delhi trial court granting bail to Disha Ravi, the 22-year-old arrested by the Delhi police in the so-called Toolkit case and charged with sedition, accused of drafting a document along with overseas secessionist groups as part of a conspiracy, the Delhi police claims, to incite violence on Republic Day. Now, the police charges were fantastical to begin with, and they are now being methodically dismantled in the judge's 18-page order. The judge has said there is no direct evidence establishing the link between Disha Ravi and the Republic Day violence. No direct link between her and Mo Dhaliwal, the founder of the Poetic Justice Foundation, said to be pro-Khalistan. The Poetic Justice Foundation, the order says, is not a banned organization. Any person with dubious credentials, like Mo Dhaliwal, for instance, may interact with a number of persons, but as long as the engagement remains lawful, people interacting with such persons can't be painted with the same hue. The creation of a WhatsApp group or being an editor of an innocuous toolkit is not an offense. Since the link with the toolkit or a PJF, Poetic Justice, has not been found to be objectionable, deleting the WhatsApp chat, which is what the police have accused Disha Ravi of doing, also becomes meaningless. Except for pointing out that the accused, in this case Disha Ravi, forwarded the toolkit to GRETA THUNBERG, the prosecution failed to point out as to how Disha gave global audience to quote-unquote secessionist elements. Considering, the judge said while concluding, the scanty and sketchy evidence available, I don't find any palpable reasons to not grant bail to a 22-year-old young lady with no criminal antecedents. Now, what makes this order significant, this order by Judge Dharmendra Rana, is that it doesn't just limit itself to poking holes in the evidence. It also goes on to make a series of statements which have a profound significance for the ongoing tension between civil liberties and the excesses of the state. The judge says the perusal of the said toolkit reveals that any call for any kind of violence is conspicuously absent. Citizens are conscience keepers of the government in any democratic nation. They cannot be put behind the bars simply because they choose to disagree with the state policies. The offense of sedition cannot be invoked to minister to the wounded vanity of the governments. The right to dissent is firmly enshrined under Article 19 of the Constitution. In mind, the judge's considered opinion, the freedom of speech and expression includes the right to seek a global audience. There are no geographical barriers on communication. A citizen has the fundamental rights to use the best means of imparting and receiving communication as long as the same is permissible under four corners of the law and as such have access to audience abroad. Now, the same judge had issued a similar order while granting bail to two individuals accused of putting out posts during the farmers' protest. This is what the same judge, Dharmendra Rana, said. He said the law of sedition cannot be invoked to quieten the disquiet under the pretense of muzzling the miscreants. The invoking of Section 124A, which is the sedition law, he said, is a seriously debatable issue. Now, this order comes hard on the heels of a bail order granting bail to Varavara Rao, the aged gentleman who's been accused in the Bhima Koregaon case. This is the Bombay High Court, which said that the continued incarceration of Varavara Rao will violate his rights under Article 21, which is the right to life and liberty. We do not appreciate or agree with the NIA's stand that no relief should be granted because of the gravity of offence. The NIA can't argue that granting bail on health grounds will lead to a deluge of bail petitions. Despite serious charges, can't be forced to live a subhuman existence behind bars. And then, of course, who can forget what the Supreme Court said in the Arnab Goswami case, granting him bail. It will be a travesty of justice if bail is not granted while the FIR is pending. If constitutional courts don't interfere, we're travelling the path of destruction. Governments should ignore taunts on television. We must send a message today to the high courts as well. Please exercise your jurisdiction to uphold personal liberty. If state governments target individuals, they must realize there is an apex court to protect the liberty of citizens.